Item number 7, he have taken permission from the other side, consent from the other side.
Yes, ma'am. Other side is not there, ma'am.
Oh, motion stage.
Government is there.
Huh? Oh, government, okay.
Government.
Is it a bail application?
No, ma'am. It's a civil matter, madam. Of course, I could have done it, madam, because another matter is there. So your loss is also rising early
Oh, yes, yes.
on 16 May. Can
Make appeal, huh? Item number 7.
No.
Oh. Okay. Learned Counsel Mr. M.H. Rajbor Bhuiya
Yes, ma'am.
has prayed for adjournment. List this matter after 1 week.
16, ma'am.
On 16th. List this matter on 16th.
Much obliged.
May I please, Lordship? I played before Lordship to agenda item number 9, my lord, orders matter, because the contacting advocate has got some personal difficulties. M. Hussain, Dr. Pandanian.
Learned Counsel, your name?
Mr. SJB Aklas, my lord.
Mr. HJB Aklas has, with the consent of the other side?
My lord, Standing Council of Railway, I will communicate it just after.
Okay. Has,
On 18, my lord.
Mr. HJB Aklas has made a request for adjournment on behalf of Learned Counsel, Mr. M. Hussain. List as he's out of station.
No, my lord, he has got some personal difficulties.
On behalf of Learned Counsel, Mr. M. Hussain, list the matter
18, my lord, on
on
18.
18th.
Masuk.
Was this item 70 for delivery of orders? Item 70.
We'll reject it. It's already rejected.
Item number 1. For every
Malad, the petition which was rejected, 10,
What about
was
the other
withdrawn.
side?
Which was
Oh, that withdrawn petition.
withdrawn.
Okay, okay.
Malad, that 461 which was withdrawn, I found Malad that application was against a revision where the Jimma was given to hear the private respondent. Private
461.
461.
Not revision, it's criminal petition.
A revision petition,
Mm.
criminal petition was withdrawn, and Malad Jimma was.
What about the other side?
Yeah, other side is not there because their application is rejected. It is only for restoration under this 482. Or the
Okay.
360.
You have given me those judgments. I have lost track of those judgments where I have kept it. I have
But
forgotten.
what I find, Mala, because very honestly,
What is the
Jimma of an elephant?
Jimma of
There were
elephant?
few persons who want to get the Jimma. Ultimately, my case for Jimma was rejected. And here the private respondent number 2.
Where is the order?
The
Last date, order, last date, there's no order here. In 461?
Not 461 was withdrawn. It is 1088 before your lordship. 1088.
But in the original file, there's no order.
It was withdrawn because the impugn order says, my lord, the matter is dismissed on withdrawal. 11222. 112.
It's not. There's no original order here.
11222. I have a certificate copy where it says the
Original order to keep here.
$461.
Huh? Kelly nine. থাকিব লাগে না?
The matter is dismissed on withdrawal. That is in 108823. The order that was placed before your lordship for restoration. Page 40.
You see, I have the original file. The original order is not there.
That I have entered appearance last time only.
We'll just check the original order. What is
Should
the
we be-
story behind it?
Story Malad, few persons want because the elephant was in the jungle. It was, we say that it belongs to purchased by my father. I have given somebody to for hire purpose and others. And the private respondent also went for a Jimma.
Who was the original lawyer?
Well, AK Puru.
Is date for up.
Okay, list the matter after 2 weeks.
Lordship may fix a date.
Fixed date, different.
I remember. Still.
Interim order shall remain in force till then.
Item 3.
Made clear.
Mm.
Lordship, it is a dispute between landlord and tenant. Lordship, there is I have a kitchen, Lordship, missing kitchen, now my restaurant, Lordship. When there is a list, Lordship, it was for here. I opposed before the landlord that to extend the lease, but it was refused. Then Lordship, I opposed.
Tender?
After 3 years, I opposed before the landlord to extend the lease agreement.
Or lease, okay.
Lease agreement. But it was refused, and suit was filed, suit was dismissed against me, Lordship, because there is no provision. I admitted, Lordship, but today I'm going to the merit, Lordship. Lordship, my only simple prayer is that they may give a send for mediation, Lordship. I may try to convince that, Lordship, only sometime requires to establish my Lordship, 30 men are working, Lordship, if it's possible. Otherwise, I have to go, I have to I-10 and Lordship.
There is no any possibility of mediation. My lord, kindly see the order that has been passed by the first trial court, civil the senior division and appellate court also. Wherefore it is clear that there kindly before that, lordship will come, the page number 21 of their plaint. Page number 21.
But
where
you see, if you're not willing for mediation, then we'll hear this on merits.
Lord, yes, it is not maintainable.
Suppose it finally at the admission stage.
Yes, Lord, my prayer is this, my lord. This is revision petition is not maintainable because the prayer, whatever they prayed for, that cannot be granted by any civil court in any course of law. So that is the observation of the civil justice.
Page number 21.
Page number 21, kindly see, my lord, their prayer, my lord. How that can be, whether that type of petition can be filed, that is. In order 7, Rule 1, Rule 11, that should have been returned immediately. That pleading was initially from that stand was taken by the defendant.
Please.
Please, my lord, the prayer number 3. A decree directing the defendant to extend the tenancy schedule room in favor of the petitioner for a period of 6 years with effect from 1/4/2017. 1/8/2017. Now, when the title suit was going on, by this time their 6 years has also lapsed. So whatever their prayer was there, that has been exhausted. So on the basis of that, the preliminary issue was framed by the civil judge, senior division. So on the basis of that, lordship will come because there are defaulter as well as there are bona fide requirements, and as per the agreement also they are not entitled because there is a specific provision, and unless and until I agree, the tenancy will be not extended. So lordship will come at page 41. 41, relevant portion at page 42. This is an order passed by the civil judge, senior division. While after issuing the framing the preliminary issue regarding the maintainability of the suit after exhausting of their limited period of 6 years. So lordship will come at page 42, para number 4. In view of the contention of but fought by the plaintiff, this court carefully examined the basis of the suit brought before it. The plaintiff, acting as the tenant under the defendant, sought legal recourse by filing a suit aimed at securing a decree of permanent injunction that mandate defendant to extend the existing tenancy lease agreement within a premises under dispute. In addition to that, seeking another relief. The primary issue at hand, petitioner to whether a court possesses the authority to issue a permanent injunction compelling the extension of the tenancy agreement for a specific duration, such as the proposed 6 years terms commencing from 1/8/2017. Under the detailed security, it has come to the court attention, there is no notable absence of the clear statutory provision whether within the tenancy law of the specific relief act empower the civil court to decree a permanent injunction for along with of a tenancy agreement with a while it is recognized that the tenancy hold the right to seek the legal protection against the unjust eviction, lawful lacking lawful procedure. The current suit plea for an extension of the tenancy seems legally untenable in the existing forfeit. The lawsuit was instituted in 2017 to extend the tenancy agreement for 6 years, which had expired in the same year. As of today, the 6 years period has already elapsed, yet the tenancy continue to occupy the premises. A suit seeking the extension of the tenancy agreement through a permanent injunction seems legally and factually untenable. It is evident that pursuant to the extension through the legal means after the agreed period has already elapsed present challenges. The legal framework governing such a situation is clear that in this situation does not support the contention of the suit in the current state. It is crucial for the parties to adhere to some terms of agreement and take timely action in accordance with the legal requirements to avoid such outcome. Based on the consideration of presence, the court considered that the current form of the law is not viable. So consequently, the court ordered that the suit is not maintainable and is dismissed. And by the second order, there is a counterclaim. So there is some lapse on the part of the learned civil senior division. So by the next order, he has rectified that although the suit is dismissed, but my counterclaim will be continued by the next order, that is in page number 45. So after that, they gone on appeal. The appellate court also, learned civil district judge, my lord, by the order, is page 48. It is clearly, it came to the same conclusion. Lordship will come to para number 7 at page 53, where it is clearly stated that the learned counsel for the respondent submitted that very prayer the plaintiff appellant as reflected in the plaint is an absurd one, as there is no law which empowers the court to extend the tenancy, and as such the plaintiff ought to have been returned and rejected at the threshold. In any case, the period of 6 years extension of tenancy from the year 2017 as sought by the plaintiff has already expired by the term of passing of the impugned order, and during which period the appellant plaintiff had continued the possession in the suit premises. Therefore, the prayer of the plaintiff has become infructuous. So this is the findings. Their limited prayer was that that is a very absurd prayer, that under no provision that can be extended. In spite of that, the suit was continued for more than 6 years. Their prayer was to extend the tenancy. That cannot be passed by any civil court. But in spite of whatever may be, for any fault of reason, the COVID period was another, or also that was continued. And by this time, their period for prayer, that 6 years is extended. So what is the remaining issue? So accordingly, that was dismissed after issuing the framing the preliminary issue regarding the maintainability, and against that the appellate court also is coming to the same by holding the judgment of the civil judge. So my prayer is, this revision petition is not maintainable and this will be dismissed. And this is urban and control area. And my premise is forcefully unauthorized area occupying, and filing this one after another petition also to disturb the
Defense Rent Control Act.
Yes, yes, this is. And now the case is
And
for.
you have not paid the rent.
In their defaulter, it is a different thing. I will come with the evidence test. But out and defaulter, there are bona fide requirement also there. Now the case is for evidence test. So at this stage, unnecessary dragging this case before this court is, I think.
Case is at evidence stage.
Yes,
Evidence is pending before the trial court.
Right.
In this case, there is nothing stay, nothing is, no, he will not lose this case. So my simple prayer is, let me try one chance, Lordship. It is for the first time. I am praying, Lordship, in the High Court.
The revision of power.
If he is opposed, he is not a landlord.
If he wants to try, then let the fight in the title suit. Why the unnecessary revision petition is there?
They are not getting the revision from this. Lordship, they are in CPC losses.
So that counterclaim is continuing.
Yes,
that
continues. So that is for eviction. That is for eviction. They have to contest their case.
We contest there, Lordship. Yeah, Lordship, whole nation is the Supreme Court also says that if there can be Lordship, mediation is there, Lordship. In section 89 of the CPC also says that if Lordship satisfied.
You cannot go hand in hand.
Yes.
Mediation and contesting cannot go
Yes.
hand in hand.
He counterclaim, he hasn't filed, Lordship. If he has a mediation succeed, Lordship, that counterclaim will withdraw, Lordship.
He doesn't want to, you are not
No,
the
no.
owner of the supervisors. You are the owner, no?
Yeah, I'm the owner.
He is owner. Let them file then, let them file then. Now for the first time I'm saying that mediation to send for mediation.
This is no
Or
chance.
Lordship may please after hearing after 24 and then I will argue on mail. Please at least give me one chance, Lord.
Basically you are seeking adjournment.
Adjournment.
There's no element of settlement. Basically you are seeking adjournment.
Lordship, if your settlement not there, then Lordship I have to go because it is a tender. I know that I know the Lord.
You personally decide.
Lordship,
You
I know the Lord, but I will try to convince.
the owner.
Yes, I will try to convince the Lordship.
Okay. Your name, learned counsel, Mr.
D. Mohanta.
D. Monta has prayed for adjournment.
But I am not praying for any settlement.
Learned counsel, Mr. D. Monta.
D. Mohanta.
Learned counsel, Mr. P. Sohria.
P.
P.
Mohanta.
Mahanta.
Huh?
Vota
P. Mahanta,
Mohanta.
my
P.
second.
Monta.
Vota Mohanta.
Mohanta versus Mohanta.
Let's.
Learned counsel, Mr. P. Mohanta has submitted that this case may not be sent for mediation as there is no element of settlement. This matter on when do you want?
After 24, Lordship, I will be.
24 official. 2nd March.
Lordship, that day I will close.
But
Or
on
maybe
that day, the final, kindly, my lord, this should be noted that there should be permanent.
In the admission column, and this case will be taken up for disposal in the at the stage of admission.
Lordship. That's.
Item 4.
May I please, my lord? Lordship, we are preparing this appeal mainly on 2 grounds, my lord. First is quantum and second is, my lord, the driver is not having valid in the driving license, my lord. So it may be admit, my lord.
50% may kindly be deposited and the limit may kindly be allowed to.
We'll start with the IA then.
Yes, my lord.
And I'm to get the copy of the appeal, my lordship.
I have already given, but
I
hard
will
copy is
give-
not given, my lord.
Learned counsel,
Hard copy is the main
Ms. Sama
thing.
is present for the insurance
Hard copy
company.
is the main thing.
And learned counsel, Mr. A.R. Agarwal is present for the claimant. Full stop. I to likhiba, huh? The applicant from our insurance company has prayed for stay of the impugned judgment and order dated
Order dated, my lord, 16/12.
2024, passed
Yeah.
by the
Passed by,
member MACT
Dibrugarh.
Dibrugarh in connection with judgment and award likhiba, order, in connection with MAC case number 56/2029. Full stop. The applicant is agreed by the judgment as the driver was not holding a valid driving license.
Yes, my quantum and driving.
Quantum.
Holding a valid driving license. Full stop. The applicant is also agreed by the quantum of compensation which was erroneously calculated by the, which was allegedly erroneously calculated by the tribunal. Full stop. It appears that further proceeding that the operation of the judgment and award may be stayed. Full stop. Considering the submissions at the bar, the operation of the judgment and the operation of the order impugned by the applicant is stayed till the next is stayed until further orders, subject to the condition that the applicant deposits
50%.
50% of the
We awarded.
compensation awarded before the registry of this court within 6 weeks from today.
They may be,
May kindly be allowed to
I, my
proceed.
lord,
No, since
to withdraw the amount, my lord.
that claimant,
My lord,
they can kindly be
they
allowed
may
to-
file
only one
I, my
claimant,
lord.
lordship.
My lord, and
And
case
deposit should be, settlement is going on, so deposit should be in the 4 weeks,
it is
so that we can
later
place in
on,
the
my
local
lord.
lordship.
My lord, respondent number 3 is not necessary party, so he may be deleted, my lord.
I will allow it. He's saying
Yes,
that
lordship.
settlement
This is only
going on.
for quantum.
In this
Thereafter,
application-
thereafter they may file IA, my
No,
lord.
it will take time, lordship, will place in the
Mobilize
local
the-
lordship. That may kindly be allowed, lordship.
Let me allow it here.
No, my lord.
No.
They may file
Okay,
IA.
all right, I'll-
Mobilize, my lord.
No, it will dispose of. In terms of the above observation, this I stands disposed of. to MSC to Pihiba Learned Counsel, Ms. Elsoma is present for the insurance company, stroke appellant, and Learned Counsel, Mr. A.R. Agarwal is present for the claimants. The appellant is aggrieved by the judgment and award dated so and so. Hey, I got that was filed by in connection with MSC case number so and so. Contending that the quantum of compensation was erroneously calculated and the driver was not holding a valid driving license. Pushak admit, issue notice to the
Only respond number 3, my lord. Only respond number 3, my lord.
I'll strike off the name.
The name of respond number 2, driver of the vehicle, my lord.
I'll strike off the issue notice to the respond number 3. As per usual process, returnable within 4 weeks. The name of the respondent number 3.
Yes, ma'am.
2, no, respondent number 2,
Two may
comma,
be deleted, my lord.
driver of the vehicle may be struck off at the risk of the claimant.
Yes,
Call for the original records from the tribunal.
yes, ma'am.
Lordship, I have
List.
received the copy. I have not
I have
received the
already
copy.
given.
No, just now when the mobile is
Extra
given,
copies to be
Yes, ma'am.
furnished.
so what is
Yes.
mobile
Yes,
is
ma'am.
given?
I will furnish, my lord.
I cannot access.
Oblige, my lord.
No, just now when the mobile she is given, and she is claiming that she is given.
To TSC, date diya hoisile niki? You want a date? Issue list
After 2 weeks,
4
Lordship.
Huh?
No, my lord.
List after 4 weeks.
Oblige, my lord.
I have to dispose code for some deal of niki. I have to now dispose code. Thank you.
Item number 5.
Please, Lordship, it is an appeal on quantum, Lordship. It's an appeal on quantum, Lordship. So it will be admitted, I am going to deposit 50%.
What is the amount?
Amount is, Lordship, 1 crore 3 lakhs 86,126.
You'll deposit 50%. Okay. This person is person was an employee, Oil India.
Yes, sir.
Yes, really? Employee in Oil India.
Yes, Lordship.
Oh, boy, what a
The
wild guess.
amount of the thing
I was
is the
just
high
guessing.
amount, but no income tax was
No,
deducted.
no.
Yes, Lordship. A huge amount, 1 crore.
Yeah, because Oil India employees, they
Yes,
receive a very generous salary. That is the reason. Learned Counsel application to click up. I to click up. Interrogatory application 4110 4110 2025. Learned Counsel Mr. R. Viswami is present for the insurance company and has prayed for stay of the operation of the impugned judgment and award dated 35/2025 passed by the learned MSc member MSCT. Number 2, Kamrup Metro Gauhati in connection with MSc case number 2327 of 2021. The applicant is highly aggrieved by the quantum of compensation which tantamounts to rupees 1 crore. How much?
1 crore 3 lakhs.
103
103, Lordship.
126
10386
10386 126.40. Full stop. It is submitted that it is submitted that the quantum of compensation was erroneously calculated by the tribunal. Full stop. It appears that there are sufficient grounds to stay this impugned order ex parte, comma, ex parte full stop reader. Issue notice to the respondent stroke opposite party returnable within, as per usual process, returnable within 4 weeks. Meanwhile, the operation of the impugned judgment and order dated, judgment and award dated so and so in connection with so and so is stayed until further orders.
Are make it
Subject to the condition that the until further orders, comma, subject to the condition that the insurance company deposits 50% of the awarded amount before the registry of this court within 6 weeks from the date of this order.
yes, Lordship. 6 weeks.
MSC to Learned Counsel Mr. It has been admitted earlier, no?
It's not it.
Leonard R. Gusme is present for the insurance company and has submitted that the Leonard Tribunal has erroneously assessed the quantum of compensation to the amount of rupees 1 crore dot লিখি দিবা দেই কিমান আছিলে full stop. It is issue notice to the respondents through usual process returnable within 4 weeks. Call for the original records from the tribunal. Meanwhile, admit list after 4 weeks.
Obligation. Item number 50, part meter for hearing.
May I please, your Lordship? Lordship, in this matter, my senior Mr. G.R. Datta is not well, Lordship. He is suffering from high fever. So for that, Lordship may grant a short date to conclude this hearing, Lordship.
Short date.
In the month of February
Learned
only.
counsel Miss S.
SB
Chaudhary. SB Chaudhary is present for the appellant and learned counsel Miss
S. Nath on behalf
S.
of
Nath
Mr. G.R.
on
Datta.
behalf of learned counsel Mr.
G.R. Datta.
G.R. Datta has prayed for adjournment. This matter as per card on data DD.
Obliged, Lordship.
Item number 6 for order.
To by slip code report of order to pass copy upload koi by slip code
complaint claimant करने ना claimant कोई दिखा ना দুটা insurance আছে তো এখানে
In this case, as per office note dated 11/2, respondent number 2 is served. Others
You are present?
one
I'm for the
Two,
respondent
two.
number 1.
I am for the respondent number 3 is for insurance, my lord.
Okay,
Yes,
this is
others-
respondent number 2, then we will list it for hearing then.
Yes, yes,
Admission already admitted?
yes.
Yes, Your Lordship, the IA has been stayed without a direction to give the awarded amount, some part of the awarded amount. Your Lordship.
Okay, oh,
In this case, the other vehicle is totally responsible for the accident. and
This is between the two insurance companies. I am the claimant, Your
I
Lordship.
am not,
which IA?
I 1884, Your Lordship.
188?
4, Your Lordship.
the claimant's case.
Maybe he
that-
has raised objection, that is why it was.
But the limit between
we
two
want-
insurance companies.
we-
What has happened is that the awarded amount was to be, the awarded amount was to be divided between the two insurance companies 50-50 equally.
And our vehicle is not offending, that is their plea in the trial court. They have pleaded that we are not responsible, but we are held 50% liable. And the other company has already paid them 50%. So it is not that they are not getting any amount. They have already got that amount. So our prayer is that to sort that maybe fixing the next week also, Lordship, we are ready. LCR has already.
Yes, Your Lordship, next week, Your Lordship.
Will dispose
We have
of.
no- Yes.
Next week, Your
Yes.
Lordship.
And,
Next week we'll
yes,
dispose
yes,
it of.
yes, we are ready, Lordship. Only one thing, Lordship, in respect of respondent number 5, he is not served, but his presence is not required. He may be struck off. Yeah,
Will strike off.
yes, yes. And then may be hard.
All right, Learned counsel Mr. M. Setia?
Is this?
AJ Sakya is present for the insurance company. Full stop. Learned counsel Mr.
Jay Das,
Jay
the
Das is
respondent number
present
1.
For respondent number 1 and learned counsel Miss L. Sharma is present for the,
Respondent number 3, my lord.
which insurance company?
My lord, I am for
In India.
New India, my lord.
New India Insurance Company, full stop. Office note dated where
11/2, Your Lordship.
11/2/2026 indicates that the respondent number 2 has received notice. And what about that other insurance
Hi.
company?
5 may be struck off.
Not required.
No, he is divert. The New India has already paid that amount. They are not raising any DL defense.
Learned counsel for the appellant has submitted that respondent number 5 is not a necessary party and the name of respondent number 5 may be struck off, full stop. Thereby, the name of respondent number 5 is struck off from the area of parties. As the trial court records are before us, list this matter for hearing on. You want a short date?
Next week, Lordship.
Next week.
19 February.
Deeply obliged, Your Lordship.
You are for which company? For same.
For the claimant.
Item number 8.
In this case, Your Lordship, as per office note dated 10/2/26, 3 and 4 are served. 1 and 2 is already there.
My lord, otherwise the issue, if my learned senior permits, my lord,
isn't basically issue on law, my lord, whether 1663, if an accident has occurred and claim petition is filed beyond 6 months, whether that will be bar under 166. That is the sole challenge, my lord. It might,
Yes, yes. But
that is the sole challenge, which I understand, my
Yeah.
lord. My lord,
In this case, the similar fact, its ODF bench of this Honorable High Court has dismissed our petition in another case. So this is that our plea is not maintainable as because the accident in this case took place prior to coming up the effect coming into force of a new act from 1/4/2022. So in this case, accident took place prior to that date. So our petition was rejected in one case. And but my instruction is that so same in the same fact that accident took place prior to coming of the effect of the new act from 1/4/2026 to 22. One similar case is pending in the Supreme Court. So my submission is that this is one decision that our petition was rejected, and one that case is pending in the Supreme Court. Not to decide.
my lord, if I my lord, for a moment, we'll take up the order dated 18/9/2024 for a moment, my lord. 18/9/2024. Justice Ravin Fukam's order, my lord.
What about the other parties who are not present?
My lord,
They
there
are served. They are served already.
Notice have been.
notice has already been gone to them, my lord. Because it's a question of law, my lord, whether this is there or not. My lord, for a moment, we'll take up the order 18/9/2024.
Let us bring it on admission.
My lord, please, my lord, because otherwise, my lord, I have a pointed judgment, like my learned senior has said, by the Justice Ravin Fukon on this issue, whether if the on what date the FIR was lodged. I have a copy of the FIR also. FIR was accident had happened on 10/2/2020.
This is pending in the Supreme Court. Any stay granted? No.
No, my lord, I have that set out of Supreme Court also, my lord. And Supreme Court has said, my lord, that High Court, my lord will, if my lord pleases, I will submit that, but subject to my lord wants to take it in the admissions time. That also, my lord, I am ready. But Supreme Court has categorically said, my lord, it is made clear that during pendency, because Supreme Court was hearing these matters,
Yeah,
there is no stay.
tribunal may pass the order also. It has been said by the order.
My lord,
It is in the order. The tribunal may pass judgment subject to the outcome of this judgment. The Supreme Court's order.
my lord,
Yes,
because
ma'am.
there was no stay granted by Supreme
Tribunal
Court.
is allowed to continue with the.
Yes, my lord,
case.
exactly. That is what the Supreme Court has also said. In this case also, my lord, may allow tribunal to complete the proceedings, my lord, at least. These are the bunch of special leave petitions, my lord, have been filed 8412, 8413, 2023, and there are IAs been filed by various state.
You know, there's a judgment of the Supreme Court relating to bail matter that even if any cases are pending in the Supreme Court, this court can pass order.
Pass orders, yes, my lord.
But it's relating to bail matter. I don't know whether if any case of this nature, if subject is in the Supreme Court, whether court can pass order, I don't know.
My lord, under the rule of stare decisis, my lord, until and unless there is no stay granted, this honorable court can rely upon the coordinate bench judgment and my lord, if wants, then my lord I can produce, this is the FIR copy, the relevant judgments of Supreme Court, my lord, and our High Court judgment by Justice Ravin Fukon on the same letter that my learned senior friend has pointed out.
Which part you are referring to? Justice Ravin Fukon's judgment?
My lord, Justice Ravin Fukon's judgments, my lord, my lord,
Which paragraph?
Paragraph number, my lord, I have just marked it, my lord. I'll give a marking on the judgment, my lord. Itself.
Paragraph 10, last paragraph, last but one.
Actually, my lord, if I may, Justice Ravin Fukan, my lord will give me 1 minute. I'll just open it up for a moment, my lord. Yes, my lord. So the facts are stated in the paragraph number, my lord, 5 and 6. 6, it starts where the my lord Justice Robin Fokon discuss about one judgment of Kerala High Court. And thereafter, my lord, he talks about an
Okay, you just read out.
my lord, if I may, my lord.
Yeah.
It is also noted that the High Court of Madras,
Which
my lord,
paragraph?
my lord has got the Thitumoni Saloy's judgment, CRP number 102 of 2024. Thitumoni, the judgment which I
No.
my lord will take up the
This is Hussain.
my lord will see the Thitumoni judgment which has been delivered by my lord Justice Robin Fokon for a moment.
Jitumoni Sarayot.
Yes, my lord. So paragraph number 6, the discussion starts. My lord, paragraph number 4 is the submissions on fact, my lord. And it says it is also to be noted here that the High Court of Madras in the case of Malravan versus Probin Travels and others reported in such and such online as Madras High Court, dealing with the similar issues, had discussed rule of 159 of Central Motor Vehicle Rules and held that the said rule mandates that on the occurrence of an accident, a police FIR file and police should file an FIR and send a copy of the same within 48 hours to the jurisdictional MSCT. Thereafter, taking note of the Honorable Supreme Court's judgment in Goar Muhammad versus Uttar Pradesh State Road Transport Corporation, reported in 2023 4 SCC, the courts make that observation. Para number 7, my lord. On such count, the High Court of Madras, my lord has seen para number 7. On such count, the High Court of Madras has allowed civil revision petition to such and such and has directed the petitions filed under MSCT OP such and such has to only be treated as a reminder to the court to call for FIR and other reports and to be treated the same as a claim petition. The reasons assigned by the High Court of Madras appears to be sound and based on the relevant rules and decision of Supreme Court, and same can be gainfully applied in the present case also. It appears that the accident has taken place on 3/9/2022 at Changsari under Changsari PS, and in connection with the same, an FIR was also lodged, upon which the officer in charge such and such has lodged in such and such sections. 10. It is to be noted that in view of the discussions of Honorable Supreme Court in Gaur Muhammad Supra and also in Rule 159 of Central Motor Vehicle Rules, the investigating officer is bound to prepare an accident information report and furnish the same to the stakeholders, insurance company and the jurisdictional MSCT. The same should be treated as a claim petition. If the same is treated as a claim petition, in the question of limitation does not arise here in this case. In my case, my lord, the accident has occurred on 2/2/2020. And the FIR was lodged on 12/2/2020, my lord. I've given the FIR copy also, my lord. That's Xerox copy. Last paragraph. 11. Under the aforementioned facts and circumstances, this court is inclined to allow the petition. Therefore, it is provided that the learned member MSCT Kamrup at Amingao shall make an effort to find out whether the investigating officer Changsari has forwarded an accident information report to it or not, and then it shall call for the same along with an FIR of the said case and treat the same as a claim petition, and thereafter shall proceed to hearing this case of the matter. So, in light of this, my lord.
So this is your revision petition.
My revision petition is not this one. My revision petition is 427. That was dismissed.
Okay.
427.
This is CRP
CRP IO.
IO 353.
Yes.
For what is the prayer here?
Here also similar prayer like this case, where accident took place prior to coming into effect of a new amendment with effect from 1/4/22. In this case, accident took place in 2020. So in that light, another case was dismissed. This is 427.
So you want this case to be?
That is, I have submitted before Lordship, and
So you want earlier that MSC case to be dismissed.
Lordship, another MSC case, this Honorable Court, the coordinate bench had dismissed, had this order. That means CRP 427.
So,
This is-
so your prayer is that I'll dismiss the case.
This is my prayer that I have clearly submitted the fact, the coordinate plans. And another Supreme Court decision, Lordship, I have given one page.
Yes, yes.
Yes, that is all pending in the Supreme Court. The result is not known to me. I have instructions to dismiss.
My lord, if may peruse Supreme Court's orders, which I've also given. my lord.
You are submitting in the same line or sir?
My lord, because I am asking, my lord, this CRP should be dismissed and the MSCT should proceed with the matter. That is my submissions, my lord. Because in this case, the limitation point does not apply at all because the FIR was lodged on 12 to 2020. Once the FIR is lodged within the time frame of 6 months, then the question of delay in filing claim petition does not arise, my lord.
Yes, yes, it is there.
That is the law
Mm,
which has been settled
is
by
there.
Justice, my lord Justice Robin Foucan, by relying upon the Supreme Court judgment and the Kerala High Court judgment. So in this case also, my lord, the FIR has been launched on 12 to 2020,
So, within 1 week.
within 1 week, my lord.
Oh.
So the question of continuing, my humble submission is this, my lord. Then, my lord, it is no longer a res integra, my lord.
What is the prayer in this CRP?
Our prayer is that as it was filed beyond 6 months, case was filed beyond 6 months, so it should be dismissed. That is our prayer.
So you want this case to be dismissed here at this stage and you have no objection if it is dismissed? CRP? Because there is a judgment.
We have placed before
Fairly submitted.
what is fairly submitted.
What is the truth?
Yes, that is in respect of another case. But Supreme Court decision also I have relied and I have placed before Lordship to decide what to do.
Supreme Court has not decided.
I should interfere, Lordship.
Hmm?
Should I interfere, Lordship?
Yes, you can submit what you want to
Yes,
say.
Lordship. I don't want anything, but the simple thing is this, and the Robin Foucan's judgment was, Lordship, that was, I was in their case. That time it was remanded back. And now Supreme Court latest judgment has come that whatever case is pending for limitation, that should be kept in abeyance. Matter is not decided.
My lord, if my learned
Stay.
there is no stay been granted by Supreme Court, I have produced the judgment, my lord. What my learned senior has said, I have produced the judgment, my lord. In para number 3 of that judgment, it has been stated there. So what Supreme Court has done is basically Supreme Court has directed the High Court not to dismiss the MSCT cases. That is the other way around, my lord. Supreme Court has not allowed such kind of petitions. Supreme Court has said, in case interregram, MSCTs and High Court should not be dismissing the claim petitions only on this point that it has been filed after 6 months. That is the stay which is operating. So it is basically reverts, my lord. If I understand correctly the Supreme Court's wording, so that is what has happened, my lord. And it is not that the rule of stay is pending, my lord. In this.
Actually, whatever we done by the other MSCT courts, Lordship, we are keeping the dates for hearing in the matter. They either not dismissing nor it is started. So that can be kept in abeyance.
My lord, I have a serious
in the claimant.
With all responsibility, my lord. If my learned senior is quoting from experience, then my lord, I am submitting this that I have a judgment of an MSCT Kasar where the MSCT Kasar has relied upon the High Court of judgment and has dismissed such petition of the
MSC.
of the insurance company. It's other way around. But that is, my lord, only for as an officer of the court, I am submitting, my lord.
I don't have time also to dictate the order today. It will take some time. I'll have
My lord,
to
my lord will keep it at CAB, my lord, and my lord will dictate because we have completed our submissions.
No, CAB, cannot waste time like that. CAB, I have already reserved one for CAB.
Lord, please on that case, my lord. Whenever my learned senior is convenient, my lord. But just that, my lord, 2020 accident. I think, my lord, will. The death case.
Today, I could have passed this order, but today I do not have time to dictate. But I'll not keep it as CAB.
My lord, please.
This is a very simple matter. It will come up any other day and we'll dispose it.
My lord, Monday, if my lord wants to pick it up and.
Monday, time over, no, Monday. Oh, no. Monday, Monday you check the roster. I will be taking up this bench from Monday. We have already fixed one part-heard matter.
Any other day, my lord, is convenient.
Dismiss if I have time in the second half.
My lord, please.
Monday to no hobo. হেৰি ফৰেষ্ট ট্ৰাইব্যুনেলৰ বেঞ্চটোতো চাৰিটালৈকে বহেই।
Wednesday, my lord.
I'll
Wed-
just
There is.
pass an order relating to service of notice, and it will come up before anybody. You can, I think this is a very simple matter. In 5 minutes, it can be finished. Submission can be finished in 5 minutes and order in 10 minutes, but I do not have the time today. And if I have time also, then others must leave then. I can dictate it now, but I cannot take up the other cases. If you suggest, then I'll dictate it now.
I am junior in the bar, my I cannot suggest this.
Up to lordship.
Up to lordship, my
Okay,
lord.
then I'll dictate it.
Well.
Other matters will be left over. These are only order matters. Only order matters. So if it is
by order hearing column matter. This matter in this matter, item number 19. Other parties were not present. Earlier occasion it was said for mediation, but little bit difficulties in order by this honorable court. Within 45 days, mediation time will be completed. But within 45 days, no one
extend it.
No, Lordship, no date was fixed for mediation. That's why both the parties are absent. May I pray for, he also, my client, friend also agree for a date for mediation.
For report? No, date was fixed.
Already there was a report, there is a report, madam.
Report says that no one has appeared.
But
Because no date was fixed by this honorable court for mediation.
Okay. Learned counsel. The petitioner's prayer for the petitioner's prayer that the claim petition was barred by law was petitioner's submission that the submission that the claim petition was barred by law was not considered by the tribunal. So, sir, it was contended that the claim petition was filed on 23/12/2022 with a delay of 2 years, 10 months from the date of the accident, which occurred on 2/2/2020. Per contra, the learned counsel for the respondents laid stress in his argument that the claim petition was not barred by law as FIR was registered after as the accident occurred on 2/2/2020 and the FIR was registered on
12/2/2020.
12
12/2/2020.
12/2/2020. Full stop. It has already been held by this court in GP Moni Haloi, Elias Haloi and another versus UOI and others in connection with CRPC, abide order dated here, abide order dated 21/10/2024 in connection with CRP 102 of 2024. That paragraph 10,
Paragraph 11, my lord, 10 and 11 both.
Paragraph 10 and 11. এইটো ঘূৰাই দিয়াচোন বাকীখিনি নহ'লে কনফিউজ হৈ যাব। এইটো দিয়াচোন। I have also considered the submissions at the bar with circumspection. Full stop. The learned counsel for the petitioner has submitted that the Sriram General Insurance Company has preferred an appeal before the Supreme Court and
Against dismissal of an CRPIO 427 of 2024. Is it?
against dismissal of CRPIO.
CRP IO 427/24.
Against that, the appeal to it against করেছেন?
No, Lordship, this 427 is not related to that Supreme Court decision.
No, I
Yes,
don't think so.
That is in another case, same text.
Against dismissal of CRPIO নালাগে।
It's another.
Against a similar prayer full stop in the case of Sriram General Insurance Company versus Bhagwat Singh লিখিলা no? In the case of Bhagwat Singh and others within bracket CR 3315/2025 full stop. In the case of Bhagwat Singh Supra, the accident occurred on 14/1/2022 and the claim petition was filed on 11/11/2022. Full stop. In the meantime, comma, motor vehicle within bracket amendment bracket close Act 2019 had come into force, providing 6 months period under section 166 within bracket 3 bracket close of the Act to file claim petition. This case is fixed. This case was fixed. This case is still sub judice in the Supreme Court. Full stop. No order has been, I have considered the submission that no order has been passed by the Supreme Court staying the case of Bhagwat Singh Supra, bracket close. The Supreme Court has passed an order that the tribunal may announce the final judgment, comma, but it shall be subject to the final outcome of this revision petition, full stop. Reverting back to this case on hand, comma, this civil revision petition stands disposed of with a direction that the member MSCT number 2 Kamrup,
No, Kasar.
MSCT number 2, no?
It is only single MST, my lord.
Member MSCT Kasar shall make an effort to find out whether the IO of which place this was?
This is MSC case number, my lord, 650 of 2022.
No.
The
IO which FIR?
the FIR is with the.
No, I have sent it back.
No, yes. Oh, sorry. My lord, it is.
I have sent it back.
Yes, my lord.
Hmm.
It is Lakshipur PS,
Lakshipur
PS case number 47 of 2000.
Not required. Lakshipur PS shall find out whether or shall find out whether an accident report was forwarded to the what do you want me to do actually?
My lord may simply dismiss the writ with EA CRP because by the this my learned friend's judgment, which is
It was not dismissed, no?
No.
You're relying on the judgment. This case was disposed of, not dismissed.
yeah, but
Simply not dismissed.
my learned senior has pointed out CRP 427 of 2024, my lord. In that
Please
para
give me the FIR to put here. This FIR.
in that case, my lord,
Hmm.
the in para number 10, my lord justice says Robin Fukan has also, it is another Robin Fukan's judgment, my lord.
No, don't give another judgment. Now, please don't
Okay.
give another
So my lord
judgment.
may simply dismiss
He'll
of
get confused, you see. He has to check the judgment.
my lord may simply dismiss the CRP and allow the tribunal to proceed with the matter.
May I submit, Lordship, that Supreme Court had decided that final judgment will be the outcome of the finding of the Supreme Court. That
That
objection may also
will be always there, my lord. That is always there. But the simply
Thereby
is
to diploma person hiding. This petition is disposed in terms of the above observation. This petition stands disposed of. Keeping in mind the order of the Supreme Court in Bhagwat Singh that the tribunal may announce that the final that the judgment of the tribunal will be subject to the outcome of this revision petition, subject to the outcome of the decision of the Supreme Court. This
And,
petition.
WS, my lord, there may be a date may be fixed for filing of a WS, my lord, in there because
No.
my lord, this otherwise because and they have not filed their WS, so they may.
They'll file. Okay, I'm dismissing it. Any objection? No.
my submission.
I'll have to rise now. Date is a DD. You take a date from him.
Item number 1, pertaining to Itanagar Permanent Bench for pronouncement of judgment.
You are for the appellate?
No, Lordship, I'm for the state, Lordship.
You are for the state, okay.
Yes.
Benefit of doubt is given to the appellant.
Yes, Lordship.